Hi there, it's Billy Tarasio from the Modern Divorce Podcast. And today we are co hosting and co interviewing with my friend, fellow attorney, Texas family law attorney, Brian Walters. Brian, welcome to the show. Do you want to introduce your podcast?
Yeah, thanks for with the Texas Family Law Podcast. My partner Jay Gilbreth and we're family and divorce lawyers based in Dallas, Houston, and Austin, and happy to talk about this with you.
Fantastic. This is going to be a great topic today. We're going to talk about what happens when families are divided, and some are in Arizona and some are in Texas, and just how different the laws are and what that can mean for your case. So, Brian, why don't you describe what might typically happen in that scenario?
Yeah, let's pick a hypothetical with a married couple. Been married, say, 15 years. They've got a 10 and a 5-year-old. They've been in Phoenix for most of their life, and the husband gets a job in Dallas, and they decide he's going to kind of work remote for a couple of years rather than uprooting the family and then come back, maybe American Airlines or something like that. And so let's assume the husband has been out there for a year and a half out of that time period, where mom and the kids have stayed in Phoenix, and things go south for whatever reason, and suddenly they're in our respective offices. I'm talking to the husband, and you're talking to the wife. So yeah, and in our world, this kind of thing is increasingly common. We get these kind of situations all the time, and it's some big differences between our states, I think we'll discover, and some things that aren't so different.
I love it. So, this couple has had a big fight this weekend. The first question I've got for you is: does it matter if the husband's talking to you first or if the wife's talking to me first? Does it matter if somebody's filed?
Right. I think the talking part is just, it doesn't matter. You can, it's good to be informed. And I have plenty of people, I'm sure you do too, that come in and talk and never hear from them again, or you don't hear from them for 5 years or something because they had a fight, like you said, and then they kind of decide okay, I'll make it work. But it does matter where you file, and who files first can make a big difference. I think this is where we kind of divide the world into the child part of the case, and then the divorce or property part, because they're very different rules for those two things. So do you want to talk about the most important part, the kid stuff first?
Yeah, well, the kid stuff is clear. So, the interesting thing about divorce is that Arizona has jurisdiction over a divorce as long as someone's lived here for 90 days. And even if somebody hasn't lived here 90 days, if they've been here for any amount of time, we can file for a legal separation and then convert it to a divorce. And that would give our state jurisdiction over the divorce. Now, what about you? What are the residency requirements to file?
Good question. It's 6 months, and we do not have legal separation. I think Texas is the only state that does not, from what I understand. And so it's all or nothing. You either file for a divorce or not, but it is a strict 6-month rule. And so in that particular case, if for whatever reason, if they both moved from New York and one moved to Dallas and one moved to Arizona, it sounds like much more quickly the Arizona resident could get into court if they needed to, as it relates to the divorce.
Yes. And so in Arizona, we could absolutely file for divorce. We would also have jurisdiction over the children because this is where the UCCJEA comes into play. This is the statute that's been adopted by all 50 states that determines that only one state can really properly have jurisdiction. So while Texas and Arizona might both have jurisdiction over the divorce, only one can have jurisdiction over the kids.
Right, which is really interesting because you can have two cases going on at the same time, and one in the divorce in Texas, let's say, and the kid stuff in Arizona. It's even more confusing when you file for divorce in Texas. Under this scenario, you still have to list your kids as part of it, but then you need to kind of basically say, well, the case doesn't really belong here, but the kid part of the case belongs over in Arizona.
Now,
And
most
so,
lawyers don't even think about why it might be a good idea to divide your case. It might be in your best interest to have the property piece heard in a different state, even if it means having two cases. And that's why I think this discussion is so interesting.
I agree with you. And there's even a question, I think, about whether which state would determine child support in the child part of the case, because this UCCJEA is as it relates to child custody jurisdiction, not necessarily. There's a different statute for child support. Let's put that aside. I don't want to get too much into the weeds, but I agree with you. There can be enormous differences. Again, our state, Texas, has got some really unusual rules and as it relates to the other states, and they're normal for us. We don't even think about them, but when I start talking to lawyers out of state, they look at me like I'm from a different planet, which I guess some people might consider Texas to be a different planet. But yeah, there are real differences, and maybe we could talk about that if maybe the scenario is the dad is working and the mom is a stay-at-home mom. They've he earns a six-figure income. She used to be a nurse, but then stopped working to raise the kids, 10 years ago. And they've acquired, let's say, $2 or $3 million worth of assets. They've got a nice house in Phoenix or Scottsdale or something, and he's got a retirement. And so that's the scenario where I suspect we're going to find there's some real big differences. There are probably a lot of cases where if the parties are both working and they make about the same income and they don't really have assets, it's probably not a big deal, but I think the one I've laid out is going to be significant. So first of all, are you guys a community property state there in Arizona?
We are.
Okay, so are we. So that at least we're on the same basic page there. Do you want to explain a little bit what that means to people?
Sure. So community property is this concept of the community is created as its own entity, sort of how you think of companies having their own status. The community has its own status. And so any actions that either the husband or the wife takes on behalf of the community can bind the community. Basically, what that means is that all the debts will be divided, or both of you are responsible for all the debts and both of you are responsible for all of the money, no matter who actually did what to contribute.
Right. So you can't, if you're the high wage earner and you're getting divorced, you can't say, give me all that money back because I'm the one who worked and you didn't work. It's all going to be shared in some manner, correct?
Yeah, there's a pot and it's going to get divided. So what does Texas do that's wonky?
So, well, let me ask you a couple things. So first of all, because I know this from California, California divides that community property, as I understand it, by statute, right down the middle. It's always complicated, but it would be divided 50-50, where Texas can and frequently does divide it 55-45 or 60-40, even 70-30, depending on the situation. That's a lot that goes into that too. But so it's not a straight up even division of that community. Where do you guys stand on that?
So our statute says that all community property will be equitably divided. The case law goes on to define further that equitably is equal unless there's a good reason for equal not to be equitable. So for instance, let's say this couple had a lot of debt. It's unlikely, but let's say they did. I might argue that an equitable division would give my client more of the community property because she has less available income to pay half of the debt.
I see. Yeah, and you could make the same arguments here. We also have some kind of good and bad behavior arguments, and so we do get into things like who's cruel treatment, family violence, adultery. Those are the kind of things that could affect the division of property. And so we still have some of that here.
Well, that is different.
It makes for some interesting cases, I can assure you. So there's that. And I think probably the other significant aspect of this is alimony, which does not exist in Texas, period. We, a few years ago, have a statute called spousal maintenance that's really limited, probably less than 1% of all cases. I've only litigated 2 cases in my entire career where it was awarded, and even in for a very short period of time. It's just not a thing. And that is, I suspect, a real big difference between our 2 states, especially when you have the kind of extreme income disparity that we talked about in this scenario.
Absolutely. Like that's mind blowing. There's no spousal maintenance, there's no alimony. So we call alimony spousal maintenance here, but
Mhm.
it's what you think of as alimony. So, okay, so I can understand how if there's no alimony, and this case is in Texas, we're going to ask for a lot more than half of of the community property because my client hasn't worked in 10 years.
Right. And that's a reason the court could make, and in a huge estate, if you had a $10 million estate and the wife got 60/40 on a 20% swing, so that's $2 million, maybe those cases would come out to be pretty similar. I had one like that about 10 years ago. There was just enough there that it was California, Texas, and it just didn't really matter, because California had to divide it 50/50, and Texas was going to give her a big chunk of extra, and it was probably about a wash.
Mm.
But in this scenario, but most people don't have $10 million. And so it's a big difference. And yeah, I think that in that particular case, I think you would probably advise your client, to the wife, in this case, to probably really seriously consider, hey, you really should consider filing in Arizona, because if this case ends up in Texas, you're not going to get anything, or not any alimony, at least on any spousal maintenance, or highly unlikely to get it. And that could be a real big number. Give us a sense on the scenario that we talked about. Let's say a $250,000 a year for the husband, nothing for the wife, 15-year marriage. Is there kind of a rough estimate of what that would be?
So Arizona definitely is following the trend towards Texas. I wouldn't say that we're looking at eliminating spousal maintenance, but in general, awards are getting smaller and shorter, especially on something like a 15-year marriage where my client is a nurse and has worked and probably will be able to support herself in a few short years. I would imagine that she would probably get anywhere between, I'm going to go with a bigger range, maybe between 2 and 6 years of spousal maintenance. And maybe if it was 6, it would probably be a descending amount. So she might get a good amount. And by a good amount, I mean, if she was going to go in front of a judge, maybe 3,000 to 4,500 a month, for the next several years, to give her time to become self-sufficient, get herself, the license that she needed to work again as a nurse, and make that happen.
Right. Yeah.
Another
Yeah.
real opportunity here for her would be to ask for a large upward deviation of child support, because that is less discretionary in Arizona than spousal maintenance. There's a formula from the Steve Nash case, and it's very rarely pled correctly or litigated correctly by attorneys, but it's not really discretionary. If you can prove how much money was spent on the kids during the marriage, then you can get that amount of child support.
Interesting. That's the basketball player. I'm assuming that's Steve Nash. Okay.
Yes, that one.
Interesting. Um, yeah, and that's interesting, because we don't really, in fact, by statute, we don't consider child support as anything to do with the property division. And this is another example of, and I mentioned it briefly, that there might be a difference about where the child support was calculated. But Texas is capped, and essentially, whether you're Steve Nash or Luka Doncic, or whatever other basketball player you want to mention, they're going to pay for one. If they have one kid, they're going to pay about $1,800 a month in child support. Period. Even if they're a billionaire.
Hmm.
So, and now there's a very difficult way to get above that. Basically, if you have a disabled child only, and that's defined very strictly. So yeah, and it doesn't matter what you spend on the kids. It really doesn't. Even private schools, and that's where they've been going. Well, maybe they're not going to private school anymore.
Mhm.
So it's, like I said, it's a considerable difference. Of whatever the reason was, those are the way the laws are.
So, how does it work when you've got someone who's unable to support themselves? Or let's say, I've got a case right now that is not a 15-year marriage, it's a 30-year marriage, 35-year marriage. Wife worked for 2 years, back in 1980. Um, he makes a good amount of money, and she's probably going to get a good amount of maintenance. So, in that case, what would happen realistically to the wife?
mean, that's a case where maybe the statute would kick in for her. Maybe. But even then it will be short and it will not be that long. I mean, we're talking, a couple $1,000 a month for maybe 18 months or something like that. If, but basically again, I didn't make the laws. I think the philosophy is you're not married anymore. Go on with your life, and and figure it out. It's essentially what it is. And again, if there's a substantial community estate, the court can do something to try to rectify that a little bit. But it's that's the view, is you're not married and you don't have a claim on each other's income going forward for the most part, either direction, other than child support, and that's related to a child, not to the marriage. So.
Is that making a difference in the way people behave while they're married? Are people less likely to make the decision that one party should stay home and support and sacrifice a career on behalf of children?
I don't know if there's empirical evidence of that. I mean, the marriage rates in Texas are I think high, at or above the national average. I think it's staying home with the kids is more of an economic decision than it is anything. And of course, you know how this is. Nobody gets married thinking they're going to get divorced, and divorce is generally not the decision to get divorced is generally not an economic decision of I'm going to be 20% better off financially if I get divorced. It's usually mostly an emotional component of it. Although when it comes time to divide things, that's what you divide is money. So it is a risky situation, I think, for some stay-at-home moms to take that. I think also the statistics are that most people remarry within 5 years of being divorced. That's just that's the law. That's the statute or the statistics, I think, in every state, and maybe that's the way some people deal with it as well. I'll make it for a few years. I'll find somebody better than my husband and get on with it. But it certainly can make that transition difficult. And I think I would definitely advise a client about those differences in the scenario that we gave.
In the scenario that we gave, I think you said there was $2 to $3 million. Let's say there's $3 million in net worth.
Mm-hmm.
If they were divorced in Texas, no alimony, how much of the property would my client get?
I think in that scenario, assuming there was no outrageous behavior between the spouses, I think at least 55%, maybe even 60%. So if that's a 20% swing, that's $1.8 million instead of 1.5. So, it's a $300,000, depending on the type of the asset, probably tax-free. And I guess if you did the math on that over 5 years of alimony, that's 60 months divided by 300,000 is 5,000 a month. And so maybe you're getting to the similar numbers. But again, that's because they have a substantial net worth. And if you don't, it's a very, very, if you're some of those folks who kind of spend the money as it comes in and you come out of a 15-year marriage with little or no assets, it's going to be a stark difference. Now, I will say that there's a bit of a tweak, which is since we don't have spouse, and this may explain why we don't have alimony, since we don't have legal separation, all that time period where you're going from the time you file till you get divorced, which could be a year or 18 months in a contested case, you're still gathering the community money together and you have an obligation to support each other. So in a scenario where a case drags out 18 months, in that case, the spouse who's not working would have 18 months basically of really half of the income, not some smaller percentage of it. And that is a time period where they would have a chance to realize that and to start making adjustments to go forward. But it's definitely a lifestyle change. It sounds much more dramatic than what they would face in Arizona. So
I don't know that my client would get $300,000 of spousal maintenance in Arizona.
right.
So it's an interesting thing to really think about and to analyze. And I think it should be analyzed on a case by case basis. And I think if you do have the option of filing in one state or another, it's probably a good idea to talk to both me and Brian, and maybe
Right.
even have Brian and I talk to each other to figure out what is the best thing for this client to do. Can I ask another question?
Yes, of course.
So what if your client is having an affair with the flight attendant? How does that affect our property division?
So in Texas, that would probably weigh against him, if that was sort of the cause of the breakup of the marriage. And so, you combine that with the disparity in earning capacity. Um, now you might be looking at 65% or something along those lines, toward the wife, and so that can have a significant effect on things. That used to be difficult to prove. Not anymore. As long as I
No.
have access to someone's phone, I can tell you exactly what they've been doing and with who. So,
And can you
um,
get access to people's phones as part of the
absolutely, we
divorce?
just subpoena it, and no questions, no problems. Computers, phones, DMs, you name it. It's all coming in because it's relevant. And
Is
yeah,
Texas a no-fault divorce state?
so there is what's called insupportability, which is no fault, and that even where there's been adultery or cruel treatment or something like that, almost all of them still have written down in the divorce document as insupportability. People will kind of pay a premium to not have that, on a public document or for their kids to see. So yeah, it's that's 99% of them are granted on that basis, even though there's often been some stepping out of the marriage in the later stages of it or something like that.
So it's not really no fault. I mean, we care in Texas if you've been cruel,
Right.
if you've been a jerk, if you've withheld money, if you've, been mean to the kids. What counts is a recording screaming at your spouse, is that going to be admissible and result in money?
It might. And type of things you need to think about, those bad facts hanging out there, you probably need to settle your case, and it's probably going to cost you. So I know a lot of other states, it sounds like Arizona's kind of the same way, have moved beyond, it just didn't work out. Let's not get into the gory details, but we're all over the gory details all the time. We subpoena and take depositions of the girlfriends and boyfriends and ask them about all kinds of highly personal things that nobody wants to talk about. And where did it happen? Wow, what position? I mean, it's all, it's sort of like the Jerry Springer show sometimes here. It's pretty interesting. The other interesting thing about our state, which is that juries are allowed to make these decisions about custody, about whether someone committed adultery or not. I've got a jury trial set in 3 weeks for asking a jury to value an asset. We're going to have experts come in and talk about it, and then they're going to tell us what it's worth because they can't agree on what it's worth. So we are the only state, as I understand, that does that and gives those rights to 12 of our citizens, and instead of a judge sitting up somewhere to do it, which is quite the thing. Especially in these COVID times, it's been particularly interesting to try those. So
How often are divorce cases heard by a jury?
it's pretty rare because of the cost. I mean,
Hmm.
it triples probably the trial cost, and and it makes them twice as long, and there's just so much more. So it's way under 1% of all trials are that way. It's generally a case only where there's a lot of high stakes, and people willing to pay for it, and there's often an emotional component to it. So it's still pretty rare. We try a bunch of them for whatever reason, but it's still pretty rare. I've got 3 scheduled for the next 3 months. We'll see how many of them actually happen, but that's what's on my docket. So the dockets are starting to come back to life now, since this is mid-March in 2021. So starting to somewhat return to normal in our court system.
That's fantastic. And to me, it sounds like kind of a blast.
Well, it is, and if you're good at it, and my law partner in particular is really really good at juries, and it's very intimidating for other lawyers. It's really difficult, and so if you're confident about it, it's really an advantage. It's like, all right, sure, we'll go try it to a jury, and the other side is thinking that's not such a great plan, and it's a great way to extract extract a better settlement if that's what happens, because that's what happens, and probably you guys are the same way. 99% of them are still going to settle. 90, 98, 99% are going to settle without a full-blown trial at the end of things. It's just predictable and not worth the cost or the stress or the headache or the risk.
Well, Brian, this has been a fantastic conversation, much more interesting than a former conversation I had about Florida and Arizona. Texas sounds like a fantastic place to practice law and a terrible place to get divorced.
Well, it depends on which side of the divorce you're on.
It
Right?
does. It does depend. In
Uh,
this case, you may, based on my side, I don't want her going there. But yeah,
exactly.
yeah, it must be great. So thank you so much for your time today. It's been a lot of fun.
Okay, you have a good day.
You too.